This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're speaking about why fraud is epidemic in the United States and why even a guilty verdict of 12 counts of a mortgage fraud scheme resulted in a lengthy motion to dismiss, and why people who commit fraud have no respect and compelled a trial court to deal with dozens of ineffective motions dealing with his conviction. A jury convicted Defendant Jeffrey Young-Bey on 12 counts related to a mortgage fraud scheme he perpetrated in the District of Columbia. Young-Bey's moved for a judgment of acquittal and for a new trial. The United States District Court in United States of America versus Jeffrey M. Young-Bey, a February 28, 2025 decision found that the verdict was based on convincing evidence and denied Young-Bey's motion. A mortgage fraud scheme in the District of Columbia resulted in the conviction of Jeffrey Young-Bey on 12 counts related to the scheme, including conspiracy to commit mail fraud and bank fraud, mail fraud, bank fraud, conspiracy to launder monetary instruments, expenditure money laundering, and aggravated identity theft. Young-Bey orchestrated a scheme to steal the title to 2 properties in Washington, D.C., and convinced a bank to loan money against those properties. He created fake deeds, forged signatures, and tricked the D.C. Recorder of Deeds into memorializing the fraudulent ownership. Using these fraudulent deeds, Young-Bey and his co-defendant Martina Jones secured loans from hard money bankers. At trial, the government proved that Young-Bey orchestrated the scheme to steal the title to 2 properties and convince a bank to loan money against those properties. Using the fraudulent deed, Young-Bey and Jones worked together to strike a deal with hard money bankers, a real estate financier. Young-Bey and Jones lied to hard money, telling them that Jones had inherited the Bryant Street property and that Jones was renting it to a non-existing tenant. With the fake deed and fake lease in hand, Young-Bey and Jones convinced hard money to lend Jones $350,000 against the property. When Jones received the money, she wired half of it to Young-Bey at his direction, and Young-Bey used those proceeds to buy a BMW with a cashier's check. The jury found him guilty of conspiring to commit and committing frauds and confidence schemes, and the entire purpose of the conspiracy and the frauds was to make forged documents and lies appear to be legitimate as possible. Federal Rule of Criminal Procedure 29 permits a defendant to move for a post-verdict judgment of acquittal if the evidence presented at trial cannot sustain a conviction. The court must presume, when considering such a motion, that the jury has properly carried out its functions of evaluating the credibility of witnesses, the facts, and drawing justifiable inferences. The motion for acquittal was faced by the court, who decided that a rational jury could have concluded, with fraudulent documents in hand, that Young-Bey felt no need to lie or obscure his identity. Viewing the evidence in the light most favorable to the government, a rational jury could have concluded that Young-Bey acted knowingly and with the intent to defraud. Viewing the evidence in the light most favorable and for all the reasons stated, the court denied Young-Bey's motion for acquittal. In sum, Young-Bey is not entitled to a new trial because he has not shown any error that was substantial and not harmless that affected his substantial rights. The court's decision was based on the sufficiency of the evidence presented at trial, which showed that Young-Bey knowingly participated in the fraudulent scheme with the intent to defraud. The court also addressed various legal standards and arguments presented by Young-Bey over dozens of pages of opinion, ultimately finding no basis for acquittal or a new trial, and denied all of Young-Bey's motions. In my opinion, I'm just tired of reading cases taking up the time of courts across the USA to try, convict, argue, appeal, and just annoy the legal process by fraud perpetrators. Mr. Young-Bey was convicted in a fair trial before a jury of his peers of crimes relating to fraudulent actions, damaging lenders to live well, profit, and purchase expensive automobiles, according to the United States District Court judge. Young-Bey's conviction, as described in the multi-page opinion of the United States District Court, was founded in convincing evidence that a rational jury could only find him as it did guilty. May he enjoy his time in prison. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you subscribe, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 5,000 blog postings. Please tell your friends and colleagues about the blog and the videos so that they can subscribe. They're all free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my